Hello and welcome. It's time to have an update on the Delphi case. Now, I am a bit behind on it, but as you all know, that trial should have started Monday, which is today when this video comes out. That's not going to happen because Judge Gull, in my opinion, have made such poor rulings and is so completely unhinged, biased piece of work. She ruined every possibility for the defense to have a speedy trial. Not only by the discovery. They still haven't gotten everything they need from the prosecution, and she still haven't had an actual hearing about the Franks motions. Still. So now it is October. So, which means when I travel to the United States in August, I will visit Delphi before the trial. So it will be quite interesting to see the reactions. But there's been a few it's been a lot of documents. But I thought let's start with the really vile ask from the prosecution. Let's see. There. What? Stop doing that. There. Stop doing that. Oh, Jesus Christ. I'm so... Oh, for frick's sake. Jesus Christ. I will do it like this instead. Hold on. Yeah, it's a video. Skip ahead. I don't have the energy to let's see here, to edit this. So you get to see me work. This is how I actually do my videos. I screw up somewhat. No, full screen, for fuck's sake. Whatever's. Can you see it now? Do I have to make this bigger? Hold on. Bum, bum, bum. Fuck is wrong? Hey, look at that. Can I make it bigger now? Oh, of course not. Well, good luck. Oh. State's request for pre-trial ruling on admissibility comes now. The state of Indiana, by prosecuting attorney Nicholas C. McLaughlin, and hereby request pre-trial ruling as to the admissibility of certain communications made by Richard Allen to a psychologist. In support of this request, the state submits the following. 1. That Richard Allen has access to mental health services at the Indiana Department of Corrections, where he has been housed for safekeeping pursuant to court order. 2. That mental health personnel employed by Centurion Health provide psychologists and or counselors to whom Richard Allen has made statements. That in particular, Dr. Monica, a psychologist licensed to practice in the state of Indiana, has documented statements of Richard Allen which the state believes fall within an exemption to confidentiality pursuant to Indiana Code whatevers. The word on the town is that the state already have access to these papers, but they need to formally ask for it so they can use it. And because normally you don't get to use, I mean, there's an extreme narrow opening for anyone to get into psychologists' statements or statements to shrinks. Indiana Code 2533, blah, blah, blah. Privileged communications between psychologists and clients states in part, quote, a psychologist licensed under this article may not disclose any information acquired from persons with whom the psychologist has dealt in a professional capacity, except under the following circumstances. 1. Trials for homicide, when the disclosure relates directly to the fact or immediate circumstances of said homicide. The state intends to offer into evidence the testimony of Dr. Monica as documented in her reports entitled Department of Corrections Behavioral Health Self-Ending Observation. That the state seeks this ruling for the sole purpose of expediting the presentation of evidence during trial, to put the defendants on notice as to the evidentiary exception, and to obtain a pre-trial ruling on admissibility. This tells me they already know what's in these papers or have a hunch about what is in these papers. Here's the thing. A psychologist licensed under this article may not disclose, but this person is Mr. Allen does not have a choice but to attend these meetings. He really doesn't. And that means that it's not information obtained voluntarily. That, I assume, will be the defense argument against this. But because, as you see, look at this. Trials for homicide when the disclosure relates directly to the facts or immediate circumstances of said homicide, ... end quote. That means there are much more information, and not all might be what the prosecution alleges. No, I don't have time to look that up. But again, this is the prosecution using the fact that the state put Mr. Allen in a prison, max security prison, where he was guarded by Odinist guards. His body and mind deteriorated extremely in just a few months. We don't know what these so-called confessions or facts are, but the fact that the prosecution stretches to this length shows us that, well, how do I put this? They really have nothing. That's more or less it. Because if they had proper evidence, I don't see how they need all of this. Here's another thing I want to show you regarding that. Dun, dun, dun. Dun, dun, dun. Dun, dun, dun. Here it is. Jerry Holman testified under oath to the following. There is no DNA linking Richard Allen to the crime scene. There's no data extracted from Richard Allen's phone connecting him to the endings. There's no data extracted from Libby's phone connected to Mr. Allen or to the murders. There's no evidence that Richard Allen is or was connected to any other suspects in the case. There's no evidence found on social media that connects Richard Allen to the endings. There's no evidence extracted from Richard Allen's computers that connect him to this. There's no fingerprint evidence that connects him to the endings. We are talking about a case here now there's one thing, that is the unspent bullet, or the entire bullet. That's it. That's the only thing that actually connects him. Because you can't really say that, oh, the witnesses, I remind you, the witnesses described a small SUV, a smart car, or a PT Cruiser, or a 1965 Comet. That's the level of eyewitness testimony about this. That's it. And this unspent, which apparently they found buried 2 inches into the ground. How did they know to look for it if it was beneath dirt? That is something I'm interested in, but we will never find out. And do you remember why? Oh yeah, the prosecution. Oh no, not the prosecution. Well, probably them too. We don't know yet. The investigators lost the first 70 days of interviews. And if they are this incompetent, what else is lost? So that is a bit of the... But I have one more. Hold on. Dun, dun, dun. Dun, dun, dun. One more thingy. There. Oh. There. Yeah, I'm just going to read it. This is from the defense. Petition to strike gratuitous and demeaning commentary and/or findings from contempt order. Comes now counsel for defense counsel and in support of this petition alleges and states: 1. On January 29th, 2024, Prosecutor McClelland filed his, quote, verified information on contemptuous conduct. 2. Despite Mr. McClelland's failure to follow proper procedure, the court afforded him a hearing on his spurious allegations. See defendant's counsel motion for summary denial, blah, 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 blah. 3. The only issue before the court was whether Mr. McClelland could prove beyond a reasonable doubt that defense counsel acted willfully and intentionally in relation to purloin discovery materials and accidentally misdirected email and violating a quote-unquote gag order. 4. The court held that Mr. McClelland failed to meet this burden. 5. The court referenced the preponderance of the evidence standard was unnecessary and no applicable to the issues raised. 6. Several defense counsel with over 100 years of combined experience testified and submitted affidavits that the defense counsel in his case conducted themselves properly, typically for counsel representing a citizen accused of crimes and with due diligence and care. 7. The court has no experience in representing a citizen accused of committing a crime. Really? Judge Gull haven't been a judge for in crime court? I don't know what to make of that. I'm reading this for the first time, folks. 8. The court's commentary and findings of sloppiness, negligence, and incompetence are outside the issues, not supported by the evidence, gratuitous and unnecessary, demeaning, and have no legitimate purpose in relation to the court's order. 9. The Office of Judicial and Attorney Regulation provides support staff to the Indiana Disciplinary Commission, Judicial Qualifications Commission, and the Judicial Nominations Commission. The Disciplinary Commission investigates and prosecutes alleged attorney misconduct. Adrian Meering is the executive director of the Disciplinary Commission as well as the Office of Judicial and Attorney Regulation. 10. In ruling on most of the defense pleadings, the court simply wrote "denied without hearing," end quote. The lack of such brevity with the contempt order illustrates the gratuitous nature of the demeaning comments. 11. The comments and/or, quote, findings referenced herein is another exhibition of the court's bias against disdain for and animus towards defense counsel. It is additional cause for recusal. Therefore, counsel respectfully prays to the court to strike the offending language and reissue the order. Yeah. The prosecution and the judge tried to get them off the case again. But not even Judge Gull, a itsy bitsy tiny bit wiser since Indiana Supreme Court told her, can't do that. She simply couldn't. She knew she couldn't get away with it. And if she had issued that order, an order that you're incompetent, yeehaw, then it would have gone up to the Indiana Supreme Court again. And who knows? Maybe this time the Indiana Supreme Court could take the responsibility and yeet this incompetent piece of human garbage off the bench. Okay, I think that's it. Jesus Christ, 20% of my video is me searching for things. Well, you've seen me on my live streams. This is how it is. Okay. Yeah, so Indiana trial, October. I hope Mr. Allen survives till then. I will visit Delphi, Indiana in August. It will be really interesting. I will probably be around the courthouse. So if you're near the courthouse around August 16, 17, let's have a meetup. Okay. Thank you all for listening. Until next time, have a nice day. And hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. Okay? Bye-bye.